everybody. How are you guys? Hey, hey. Let me see who's in the cafe today. Hey, Henny and Lauren, mom and dada duo. I love it when you guys pop in at the same time. I love it. And I missed you guys yesterday because we did a late stream, right? We did a late stream last night about Karen Reed. If you didn't catch that, watch it on the replay because it's the last live stream I did. It's easy to be found. Anyway, hi. Hey, Gail. Good to see you. Hey, Jaloon. Always good to see your face. Hey, Gail. How are you doing, Gail? How's your foot? How's your foot, ma'am? Hey, Megan Martin. Welcome. Let's see. I'm doing good, Chaloon. I'm doing well. How about yourself? Hey, Morgana. Hey, Morgana. I think Morgana and Megan are an aunt and niece duo. I figured you were, Lauren. No worries, honey. No worries. Hey, Margaret. Good to see you. I saw you got the replay, Henny. Thanks for watching. And I knew you guys were going to be asleep. I was like, I know that my girls, Henny and Lauren, are going to be asleep. Hey, Sherry. Good to see you. How are you? I've missed you. Sleep deprived. Oh, no. Oh, no. Walking in a boot still hurts like heck, but getting better. Well, I'm glad. I'm glad that it's getting better. You just keep doing what the doctor's telling you to do, okay? I should have got a coffee fill up, you guys. I'm like to hear. This is not good. This is not good. All right. So we're going to get into this. Oh, you've been busy today? Margaret's fighting an army of ants. We've had those here too. We've had ants in our mailbox. I know that's super random, but we've had a lot of ants in our mailbox. I don't know. But someone told Dale to put a dryer sheet in the mailbox and that would get rid of the ants. And you guys, it worked. So maybe put a dryer sheet if you can handle the smell. I can't stand the smell of most dryer sheets. But anyway, okay, let's get into it. So welcome everyone. Welcome. Thanks for joining today. We are back on a daytime stream. Kiddo's knee is doing much better. She's still whistling. She's got her whistle. I can hear her whistling right now. I want to talk about Alexee Trevizo. So you guys know that I'm behind on the times with this case. And I did not know until I stumbled upon shout out to Down the Rabbit Hole News. I found her, I follow her on YouTube, but she had posted something about a month ago, and I didn't see it until I was just scrolling through my feed because I was looking for Alexee Trevizo stuff after we had started talking about her case again. And you guys, did not realize that there had been some movement in that case. You guys know we're supposed to be having, I think, another hearing on July 22nd. So I'm anxious to hear how that goes. But in case you didn't know, her lawyer, if you remember, he was talking about like HIPPA stuff, all that kind of stuff, right? Violation of her rights, etc. Blah. But he filed a motion to suppress, um, and you guys, the judge granted it. Like back in June of this year. He filed the motion last year, and the judge granted this motion. I can't. What does that mean? It means that all of the body cam footage in the police presence and all of her statements, like nothing was crying, blah, blah, blah. The discussion between her and her mom there in front of the police officers, none of that is going to be seen by the jury. Hey, Miss King, you saw it too, Margaret? Oh my God. Like, what is happening? What is happening? So, we had talked about this the other day, the last time we watched or talked about Alexee Trevizo, and I was like, you know what? There, like, where does HIPAA rights turn into, like, evidence when there's a crime committed? So it's all very, very confusing, okay? And I found this motion hearing that we're going to look at. So I'm going to go through the timeline real quick of what we're going to go over today. So today we're going to watch this motion hearing that happened back in August of last year. Okay. He talks about there's a lot of stuff on here from Mr. Mitchell, her attorney. We're going to watch through that, and then I'm also going to show you guys the motion that he filed to suppress all that information based on HIPAA and, get this, Miranda rights, because apparently they didn't read her Miranda rights and she was actually detained at the hospital. I don't know. It's all very confusing. Very confusing. So, we're going to look at the motion to suppress, and we're going to look at the motion granted from the judge. So, that's what we're going to do today. The state has filed an appeal on this motion to suppress. We'll see what happens with that. I don't know if they're going to talk about some of that on the 22nd. But as of now, her trial is still scheduled for, I think, August 26th. So I fully expect this to become more and more talked about on social media and on YouTube because it's coming up quick. So, yeah, I know you guys are like, wait, what? I know. It's awful. It's really, really bad. While we're watching this motion, I'm also going to make a poll. So I wanted to make sure that a lot of you guys, when we were talking yesterday, I said that I was going to create a poll in the chat today, and that it was going to be an important poll. So I haven't made it yet. It's not in the chat yet, but I'm going to do it here momentarily while we're watching this motion hearing. So are you guys ready to get started with this nonsensical nonsense? I know you like polls, Margaret. I know you like polls. Yes, yes, yes. I know you do. All right. So let's get into this. We're going to get into this and mm, mm. I don't even know what to say. When I saw this motion to suppress was granted, I was like, "No way." I was so mad. I was so angry. Um, well, don't get me wrong. I'm all for if someone's rights are violated, they're violated, right? Um, but the bottom line for me is that babies' rights were violated most of all, right? That's where I'm like, I can't. What really sucks is when someone does something really, really terrible, but then legalities get in the way and can somehow cause um, justice to, well, justice to be served, so to speak, I guess. I don't know. I don't know. It's very sad. This is very sad. So I'm hoping and hoping and hoping that somehow loopholes are found that can change this motion to suppress decision. I don't know. I know that they say that because the hallway footage, like, the footage that we could see where she ran down the hallway holding her bottom, runs into the bathroom, her mom goes back and forth, the nurses go back and forth, the doctor goes back and forth. We see, the whole thing with the trash can in the bathroom or in the hallway, the housekeeper doing all that. So I'm thinking that they're saying that all of that is still can be used by the prosecution because it's a public hallway, but anything pertaining to inside the room when the police are there um, cannot be used. And then also something about the doctor um, acting as a police agent or something. I don't know. I have no idea. It's so super confusing to me. Um, but we're gonna get into it. We're gonna get into it. So let's start this motion hearing. Um, and I will mute myself while we get this going. And it's a Zoom call. Um, so just so you know. Chaloon says maybe if she was under 18, I could possibly understand it, but no, Miss 19-year-old. I know she was 19, right? But it has to do with a lot of loopholes about her privacy rights being violated, other things. Hold on just a second. Okay, you guys, I had to turn my camera off for just a minute because the child came in here. But let's go ahead and get started on this. And hopefully a lot of it can be made, some of it can be sense be made out of it. But let's go. I'm snarky too. Makes me angry, Chaloon. 100%.
Okay, good afternoon. I see Mr. Mitchell. Got a lot of people. There's Miss Lou.
Okay, so let me just kind of give you who the key players are. The bottom left-hand corner here is the judge. This gal here is one of the prosecutors that's prosecuting the case, or the Alexee. And then this is her lawyer. And you'll see back here in this little at the end of the table, that there is Alexee Trevizo herself. Okay. So some of these other people, I'm not sure who they are, but it was a public Zoom hearing. So there were a lot of people that comes in and out. Also, they do have some trouble with some trolly person coming in and like muting the microphone every few seconds. So that was annoying. But, judge or courts further, maybe you should you figure out how to get Zoom figured out so that, hold on a second. Hold on. I got okay, there I am. Maybe figure out how to work Zoom so that you can mute everybody ahead of time so that nobody has any control or access to any audio or videos that they can turn on or anything like that, except for the people who you want to hear from. Okay. All right. Megan says if it happened at her house and she was speaking to police, they would most likely allow it. Maybe because it was at the hospital. Probably because of HIPAA stuff. I'm not sure, but it's a really sucky loophole. I mean, and I don't even know if I want to call it a loophole. I'm still really confused on when it becomes a crime scene, um, when it goes from hospital stuff, HIPAA stuff. And there was a lot of questions because her mom was in the room. She allowed her mom in the room. So how was she violating her HIPAA rights? Um, Stuff about the police body cam. I don't know. It's crazy. Um, it's just like a big ball of messed up yarn, and trying to untangle it's pretty hairy. So, all right. I just wanted you guys to know who is who on the Zoom. So let's continue. Right? Let's go.
She's also signing in. Is that your client in the background, Mr. Mitchell?
It is.
Okay. All right. Okay. Thank you, sir. Just want to be sure we got our necessary parties here. Let me call our case number. This is, excuse me, CR 2023-159, State versus Alexee Trevizo. Diana Luce is the district attorney. She's appearing for the state. Mr. Gary Mitchell appears as counsel for the defendant, and she is also appearing in person, virtually in person. So, counsel, we've got several matters to go through this afternoon, several motions. I wonder, do you have a preference as to the order? I was proposing we deal with the venue change as the first order, but if you have something else you'd rather take in any other order, I'm fine with that.
No, Your Honor, I can do with the venue. It'll be pretty quick.
Okay, all right, okay. So it's your motion, Mr. Mitchell. I'll let you tell me what I need to know, and I'll hear from Ms. Luce. And I do have your pleadings here, of course.
Sure, and I'm not going to repeat those. Your Honor, classically, we'd have a hearing over whether or not Eddy County is free from exception, and I'd file affidavits and do all that. But the new basis for doing these change of venue motions virtually has turned into something that was suggested several decades ago by judges like Allen and some of those judges. Whenever we would, they suggested that rather than do change of venue motions, that we send out and ask the courts for questionnaires, and we send out questionnaires that we ask people to fill out under oath, and then the council reviews those questionnaires to see if by perchance we can get a jury, which seems to be much cheaper and frankly a better way to do it. Ms. Luce kindly sent me the latest questionnaire that they used in a similar case out of Hobbs or out of Lovington. I got that. She and I can make some modifications to that. The trial date that you sent earlier today is acceptable to me. I think it's acceptable to Ms. Luce, and we can figure out with you and the court clerk when we should send those questionnaires out via Google. However we're going to do them, that's up to the clerk, but I'll get with Ms. Luce. We can work up that jury questionnaire, get it sent out once we get the new panels that would be sitting for that trial. And then when we get the information, we can figure out when counsel can sit down and go through that with the court, move to strike certain jurors who, by the answers on the jury questionnaires, have given us sufficient information for which they could not sit fairly and impartially, and decide if we have enough jurors to select from, and then go from there. I would propose that to the court as a way to resolve this issue rather than have a lengthy hearing today over whether or not this case has nationwide publicity, countywide.
Yes, Chaloon said he said a similar case. Yeah. So it was really strange because round about the same time, there was another gal. So this gal's name is Alexee Trevizo. I'm saying it quietly because everybody that has those, machines from Amazon that you can talk to, Alexa, it always makes it go off whenever I say her name. But she's from New Mexico, has this baby in the hospital, throws it in the trash in the hospital. At the same time, there was another case, or around about the same time. That girl's name is Alexis Avila, Alexis Avila, or something like that. She's from New Mexico. She had a baby and was caught on video surveillance putting this baby in a dumpster. That baby did survive. It did not, liar, Steph. She said mine just whispered, the storm. My microphone is up here in case y'all are wondering why I'm like, the storm. Anyway, so that's what he was referencing. Just a heads up. And we might look at that case eventually. They've already had her trial. I think she's serving like 16, 15 years in prison or something. Something like that. But yeah. So let's go.
Publicity, statewide publicity, or world publicity. It has all of them, frankly. So trying to move to another jurisdiction in New Mexico may not be very suitable, since the whole state has some of the same media sources, and particularly social media has been so explicit in this particular instance. That's the solution I propose.
All right. And are you on board with that, Ms. Luce? I mean, it sounds rational. We all know there's no place to go that somebody hasn't heard about the case, that's not the standard for qualifying or disqualifying, but nevertheless, there's no place we can go that would be any different, my opinion, than Eddy County. And I think that's what I'm hearing from Mr. Mitchell. Are you on board at least with the concepts?
Yes, Your Honor. That's why I provided the supplemental questionnaire we used in the case that we tried in Lovington, so that he could see the questions we did. Obviously, he and I can confer. If we can't agree, then on it, we can have a hearing before the court. But I think if we can agree, then we can just submit it for the court's approval. The court can submit it to the clerk's office.
Brenda.
And they'll
Hi, doll.
digitally upload it, as they did in Lovington, and then they'll send it out paper for jurors that need that. But I think that resolves that motion for today.
Okay. And folks, let me take, it's above my pay grade. I don't know how Martha does her work down in the clerk's office, but my suggestion is that we get with her early enough, and this trial's not going anytime soon, so we should have adequate time to let her know we're going to have to get an unusually large number of jurors pulled in.
Right, Brenda.
To examine
a
a panel.
conversation.
Just the length of the trial alone is going to make it difficult. to get an adequate veneer to pick from. So at least we've got some ramp up time, and then I'll let Martha know, kind of be warned, we're going to have a really, really large number of prospective jurors to sort out, I think, in this case, just to get enough people to sit on a panel. And I think you told me you expected 6 weeks to try this. Is that right?
Yeah, that's what I estimated, but a lot of that goes to jury selection. But if we do, and I don't know if Ms. Luce has found this to be the,
I'm glad you were summoned, Megan. I love having new faces, and I know you've been here before, but I love it when you come. I love it when you come over here because, yeah, I love when we have duos, pretty cool.
the solution as well. I found if we do a decent supplemental jury questionnaire, that cuts down on the amount of time we need for voir dire. So we may be able to get it done within 4 weeks if we're not having to do.
So you're counting the 6 weeks, a good part of that you're counting also pulling a jury, right?
I am.
Okay. So the extra trial portion won't be 6 weeks. You were accounting for finding a jury to sit.
Right. I counted 2 weeks for jury selection.
Okay. All right. Well, we will keep that in mind, and I will just try to start anticipating and plan ahead as much as possible on getting that taken care of. Okay. All right. So that issue's off the table. I've got 2 other pending motions. I have the one to modify conditions of release. Then I have the other, which is the motion to suppress, motion for protective order, exercise of privilege, and the Pena Espinosa procedure termination. Which one do you want handled next? You're muted, Mr. Mitchell.
Let's do the privilege one next. It's
Okay.
all of them, because I think I can argue the whole thing, and we'll save the release provisions to last. There's
Okay.
also a motion that I filed. The state didn't respond, but to take the deposition of one of these,
Oh, no highlights,
just a second.
Brenda. No, no.
The toxicology experts, it's in Pennsylvania. The state sent some of their lab testing to Pennsylvania, and I didn't want to be without that expert for whatever reason. But that's something we can do later. But we probably need to take the deposition for purposes of trial of that particular witness. So we're not either one of us hung out to dry when we need that toxicologist, and we don't have them available because they're more than 300 miles away.
So this is a toxicologist for the state, and you need the deposition of this toxicologist. Am I right on understanding that?
Right. At the preliminary hearing in this matter, the state objected to my just getting into that with the forensic pathologist or any other doctors, saying we needed to have the toxicologist here. I want to avoid that. I've dealt with that issue with the same toxicology group before, where we tried to bring them from Pennsylvania or the state tried to bring them from Pennsylvania. And normally somebody calls me and say, Gary, can we take their statement or their deposition? And that's all I'm saying. We just need to take the deposition.
Okay, but that's not right for today. We're going to put that up for another hearing, right?
That's right, Judge. I'll talk to Diane about it, to the district attorney about it, see if we can reach an accommodation, if we can take that witness's deposition and introduce the report. The report's what I need or the state may need, whichever one of us needs it. Thank you.
Okay. All right.
I'm ready to argue on this motion to exercise of privilege. Let me say, and there was some confusion yesterday, but we didn't send these exhibits, but to the court via your email and to the district attorney via her email. So these are exhibits I still think need to be sealed for purposes, but I sent exhibits A through I just for the purposes of this hearing. They're not to be admitted at trial or anything. I'm not asking that. Just for purposes of the hearing. They included the records of the hospital, which I think are privileged, and for the court's edification, the 2 lab reports that we needed. And then we had certain police reports, and I noticed and looking here, both officers are present. I guess we could take their testimony if we need to, but I attached their reports, Williams and Anaya. And then there's a videotape that the state doesn't have that I'm aware of, nor do I have, but I've seen on people sent it on social media. It's from Artesia General Hospital, and it's a videotape of my client going from a examining room down the hall to the bathroom and then coming back. Another Artesia police officer took that tape, figured out a time schedule. That's Exhibit G, a timeline. I believe that was Officer Minter, and I attached his report showing the timeline. And then there's the videotape that we seek to suppress, where police officers, the doctor, and my client are and her mother are in the examining room. That's the Miranda issues. And then I did a timeline of events to give the court, without you having to examine every medical record, to give you a timeline of what we're talking about here. So I'm asking that those be admitted for purposes of this hearing and that they be sealed.
All right. You got any objection, Ms. Luce?
Your Honor, I don't have objection to the video, to the police reports, to the lab reports for purposes of this hearing. The timeline that has a caption on it appears to be Mr. Mitchell's work product summary of what everything purports to be and purports to happen. If that's a proffer by him of what evidence is, and the court is to consider it only as a proffer, the state doesn't have an objection. Otherwise, that's basically argument. And the state's going to object to that being a written document, with us only getting it last night, coming in before the court.
Okay, I saw a thumbs up, from Mr. Mitchell, right?
Judge, and I knew that, and I expected to just use it as a proffer of what the records show. Ms. Luce didn't say anything about Exhibit A, which are the medical records that came from Artesia. I copied those straight from what the state gave to me. So I don't know if the state has an objection to those. You're going to have to look at them some point in time to decide what is going to be admissible and not admissible under.
All right, you guys, the poll is up in the chat. Please go vote with your vote, okay? So there are options. You guys know we typically cover trials, but once Karen Reed was done, I decided to take this opportunity to go over and discuss a few different options. And there are other options. It only allowed me to have 4. But there are other things that I want to talk about too, like Stephen Stearns and Madeline Soto. Micah Miller for one. There's several, but I just put in 4, and I included the Alec Baldwin
storm tracking team, a tornado watch has been
trial in there because we're also trial watchers, right? So I just wanted to put some options in there. Now, that does not mean that we will not talk about, whatever the main one is that you guys vote for. That doesn't mean we're not going to talk about the others. We will at some point. I'm just kind of going to use what you guys vote for from the majority to the minority as the I lost my train of thought. As which one I'm going to cover first, right? So anyway. Does that make sense? Chaloon, go ahead and Google. You don't have to vote like right now. I'm going to leave it up for a while. So I'm going to leave it up for a little bit. Going to leave it up for a little bit. Dun, 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 dun. We're at 8 votes right now. Okay, so I'm going to get on with this. I just kind of wanted to give you guys an option to get your votes in. And if you haven't already clicked the thumbs up on this video, I would appreciate it. I would appreciate a thumbs up on this video. And if you're watching this later, after the live is ended, then make sure to leave a comment in the comment section down below and use the hashtag replay crew or replay to let me know that you're watching on the replay. If you stumble, oh my God, Lord have mercy. My phone will not quit. Hey babe. Did your knee feel better? Yeah, good. Let me see. Anti-dolphins and manatees, you guys. Yeah, the Madeline Soto thing it's really bothering me. Jillian says I'm just listing as I Google. Oh. Yeah, Sherry is the kidnapping hoax. Yes. Sherry is the kidnapping hoax one. There was a new documentary put out by that one. And then Jocelyn Nungaray is I think that's one Miss King put out. And that was a 12-year-old little girl, I think. She was 12. And she was killed out somewhere in Texas, I think. And then Rachel Sheridan was a DV situation. She'd been with her boyfriend for a long time, few years, I guess. And he killed her. He was just arrested. And there were rumors that she was pregnant, but there was also rumors that she had lost the baby prior to. So I don't know yet. I don't know if it's a situation where we're going to have to wait on autopsy. So yeah. Was it El Paso or was that just where the guys crossed the border? I'm not sure. I can't remember what part of Texas it was. But yeah, it was 2 guys that I'm not positive if they how do I want to say this? Were here legally or not. I think they were, but I don't know. Jocelyn was essayed, yes. I can't remember which country either, Steph. Venezuelan, Argentinian. I'm not positive which country they're from, but I'm also okay, they were not documented. Okay. I thought that they were here. I thought that they were documented. Um I thought that they were. But again, that's another, that's something we'll have to look into when we dive into it if we when we do, but I'm not positive about all of those. I'd seen her name scrolling across my, news feeds and stuff, but I didn't really know what was the deal with it until Miss King had mentioned it the other day. And then I kind of looked into it like for a brief second. It's a very sad situation, but I do know that they got the 2 guys on, um, like, surveillance outside of the 7-Eleven. It was 2 guys, Chaloon, not just 1, there were 2. 2 of them that did this to her, and from what I gather, I think one of the outlets I listened to or watched said, that she had been, um yeah, essayed, and, they were waiting on DNA to come back, that kinda thing, but her body was found in water, so I don't know how good the DNA samples they got are gonna be, I don't know. It's very sad, very, very sad. It is horrible, right? Alright, so, we are at 13 votes, you guys, and it's kinda neck and neck. Um, all of them are very, very close, in votes. So I'm gonna keep this poll up, and, Venezuelan nationals not documented, says Steph. Okay, well, for some reason, I thought that they were, but I wasn't positive. I think I had heard someone say that, um, because they were trying to flee the country in water with their pants off. Yeah. But said that they were trying to flee the country, and it may have been Nancy Grace that I watched it on. I can't remember. Um, but whoever it was I was listening to said that one or both of them tried to flee the country, and that, um, why would they, work so hard to get into this country and then turn around and do something to get themselves thrown out? You know, I don't know. Or not get thrown out, but to get themselves thrown in prison, Jalen says, I'm more interested in regular people than a famous actor. Besides our dear Mr. Depp. Right. QB is going to bribe people to vote for Baldwin. She's wanting to watch the Baldwin trial. I know. I'm neutral I'm neutral on that. I don't think they knew how many cameras we got. Maybe. I don't know, but they were sure found on camera at the 7-Eleven. One came over and was on ICE radar, but they were still here illegally. Ah, wow, okay. Uh, all right, you guys, we got off topic, but we're going to get back to this motion hearing. Just make sure if you pop in to please vote in the poll. Please vote in the poll. All right, let's go.
The privilege.
Now, counsel, I don't have any of these actual exhibits you're referencing. Where are they? Have you tendered them?
We sent them to your TCA via email
Oh,
today, and she should have them.
you did. Okay. She said she sent them to my email. Let me check. I'm sorry. I missed them on my email if she did. Hang on a minute. Let me look.
It's a lot. It took several emails. I think we put them on a,
I'm not
Oh my God, Jaloon. That comment just made me cackle hard. You ain't lying, girl. You're not lying. She's probably sitting there going, Lexi, shh, don't say nothing, Lexi. Because, you know. Oh, thank you, baby. Thank you. All right. All right. Let's go back. Let's get back.
sure. I've got one that does not appear. It's a reference. Here's the link for exhibit F. That's not it, right?
well, there's an exhibit F, but we put them on a link for purposes of the court. I didn't anticipate that you'd be able to go through them all. I figured you might take some under advisement after you heard from counsel today.
I will do. And Emily, will you do this? Print them up for me. Just print them and we'll put them in a folder also, because it just helps me to have them in hard form. She'll get them up and I'll look at them later. Will that work for you folks as far as this goes?
It will, Judge, because
Okay.
the argument is going to be, anyway.
Okay.
I do need to know if the state objects to exhibit A, which were their medical records.
Your Honor, not for purposes of this hearing, for the court to consider them. Of any objection to any of these, as I've let defense counsel know, being sealed, not public for purposes of the record for various reasons. And so I don't have a problem with that, Your Honor, but I just wanted to make sure that the one that is, I believe, the timeline of events was the proffer to the court. Since it had a caption on it, it appeared to be prepared by Mr. Mitchell or along with his staff.
It was prepared by me, Judge, and a proffer is all it is. And that's really put the style of the case on it. So
Okay. Okay.
all right.
So, all
I'm ready.
right. With that said, let me hear your argument, Mr.
Sure, Judge, and I'll be as succinct as possible. And when the court reviews the argument that Ms. Luce made regarding HIPAA and the argument I made, we both agree under the law, there's not a remedy under HIPAA for one exercising the privilege. There are fines that a hospital and doctors pay for violation of HIPAA, but that has to do with the Department of Justice and their investigation and Medicare and Medicaid and whatever they decide to do. But for the individual, there's no remedy under federal law, under HIPAA, that you could exercise. You can't sue for damages or anything like that. So my purpose in bringing this today, however, is under New Mexico law, and I cited the court to this. Rule 11-504 is a physician-patient privilege in the state of New Mexico that we believe applies. And I, in my brief, cited the court to Bertrand and Roper, which are the two key cases for the exercise of that privilege. Our position is we have not waived this privilege in any way. We did not sign a waiver. It applies to the doctor. It applies to all hospital personnel. It applies to Artesia General Hospital. And later on, it applies to the hospital in Roswell where she was taken. So and that's one reason I attached a timeline so the court could know. This entire case hinges around what happens in a bathroom and the emergency room of Artesia General Hospital on the date in question, which was January 27th of 2023. The timeline will tell you that there's one admission sheet that says 12:03, but by 12:05, she's in the emergency room. And then within a few minutes, she receives medication and through an IV, and including morphine and several other different kinds of medication, as the timeline would reflect. Without getting into that too much, she's examined by an emergency room doctor. She has a nurse that's there. People come in. The hospital asks for a UA. And blood. They do a blood test, and by 12:51, they know that she's pregnant. And then we know, when it comes to this privilege, that according to and they happen to have a video camera or some type of camera in the emergency room part of Artesia General Hospital that shows her leaving her room. And we know from the records that at 1:39, she leaves they go in, they unhook her from the IV, let her get up. She virtually runs down the hall, trots down the hall to the bathroom. And then, according to the police report that you have from Officer Minter of the Artesia Police Department, who reviews that video and goes through it, she's in the bathroom for approximately 18 minutes and then leaves the bathroom and goes back to her room. And then by a certain time period, and let me pull that up so I can speak intelligently to the court. We know that after the 18 minutes in the bathroom, we know she's back in the room, and we know that emergency room personnel go in and they begin, the cleaning staff goes in and they begin to clean the bathroom. And later and that begins at 2:08. And then by 2:27, they find the baby. And at 2:38, the doctor pronounces death. And then police arrive after that. So when the police arrive, the doctor wants to wait for the police to get there. I don't think this is disputed at all. She waits to talk to the two officers from Artesia Police Department, both of whom I've attached their reports, the sergeant and the officer that came in. And I've attached those as exhibits. So they come in, they talk to the doctor, and then they go in the room where she is. And the doctor walks up to her and asks her and tells her they found the baby, and asks her, says something to her. You have the videotape of that. It's a lengthy videotape for you to examine of that time period with the officers there. The officers both say in their report that they told her she was detained, could not leave, and for purposes of Miranda, I would argue in custody and not free to leave, which means that at no time is there anything read about Miranda, which gets us to the suppression issue. But back to the privilege, the key question is to determine, when does this privilege apply? Well, it applied from the first time she went to the hospital. That's real clear under the rule and under the case law, and it applies to everybody there. And really, the state's case is the time in the bathroom. And then it applies afterwards as well. So my position to the court is everything that takes place between the time she goes to the hospital all the way through is privileged information that the doctors and the nurses could not give out to Artesia Police Department, could not give out to anybody without a waiver from my client, and we've never waived it. In addition,
Yeah,
I'm-
what is Are you talking statements made by her and her medical records?
Yes, Your Honor, and that would also include lab reports and stuff.
Okay,
Anything that happens at Artesia General Hospital, and there's a case on that as well that says, hey, that includes lab.
yeah, I want to look at the annotations. I don't see that. I'll have to pull it. Let me ask you another question. Is information, because obviously cleaning staff, what, about 2 hours after the event? Is that what you said? They go in around 2 in the morning?
Yes, at
And then around a little past midnight, cleaning staff goes in around 2-ish, right?
that's correct.
And they discover the deceased child.
Yes, after they're in the, I can tell you the exact times on that based
Okay.
upon the records and stuff. At 2:08 in the morning, the ER staff, janitorial staff started cleaning the bathroom. At 2:27, they call in a male nurse because of what they found in the bathroom. They found the baby, and then that nurse takes the baby into an examining room. And at 2:38, the doctor pronounces the baby deceased.
So let me ask this. Notwithstanding a doctor-patient privilege, what about the hospital's obligation to report the deceased child? Is that privilege? Are you claiming that as? Okay, that's where I was headed. Okay,
They have a duty to report it. They call 911. It turns out that the police were there. The emergency room wasn't busy, but it turns out they were real close by anyway. And they were there quickly. But no, they have an obligation to report it. I'm not saying that. I'm saying this, and I'll try to be as succinct as possible. Really, everything the state's case hinges on what happens in the bathroom, and there are no other witnesses but my client to that. And whatever the experts are saying, whether it's OMI, my experts, or and such, are going to say about that. But basically, that's the situation. Is that for that 18 minutes, there are no other witnesses, but everything before that, because there's no case before, she doesn't have the baby except in the bathroom, Judge. That's the point. And before that, there were no issues that I think aren't covered by the privilege. And then after that, obviously, she's they end up taking her to a room. Obviously, people see all the blood, and they realize they have to do some examination. The doctor goes in, doesn't talk to her because they don't know that she had a baby, but they think there may be other complications. And then after they confront her, the doctor and the two police officers in her room, then after that, the doctor intervenes again and says, listen, I got to helicopter her. We got to airback her to Roswell. We don't have people here in this hospital to take care of it. And she is bleeding to death if we don't get her treatment at Lovelace and Roswell. So they airbacked her to Roswell after that. And of course, the police let that happen, although she was in custody at the time that they went into the room. The doctor specifically states in the reports, and this is not in dispute because it's in the records and it's in the police reports. The doctor deliberately waits after they find the baby. The doctor deliberately waits until, and no other staff goes in until police officers arrive, and they all go in at one time. And that's where we get into the Miranda issues. So for the privilege,
All right. So you guys are catching all this, right? I mean, all of this, see where it gets so super hairy? Are you guys seeing that? I keep going back to this. She did this, right? She did this. But it's these things that can potentially get her off of this. And it's so frustrating and scary.
I'm saying everything's privileged up to the time she goes into the bathroom. Everything's privileged after she comes out. because it's all part of the privilege.
Okay,
And-
now let me stop you
Hey,
here because I want
Patricia.
to clarify. I'm looking at Rule
Did you
504.
just sneak in, Patricia?
We have the doctor
Hi,
patient
if you did.
privilege. This is an exception to the other rules. Who has the obligation? Does the doctor and is this in case law? I'm not seeing it here in the privilege. It says who may claim the privilege. Is the doctor obligated under this act or anything else to invoke it or at least advise the patient of their privilege or invoke it on behalf of their patient? What is their obligation?
The doctor and the hospital's obligation is until they have a proper waiver of that privilege, they can't talk about it. And here's,
And
and
then
that's,
she has to make a knowing waiver after being advised what her right is in event to waive it.
well,
Right.
there's no case law on what a knowing waiver is. That's always been, did she sign a waiver?
Okay.
We've always done that on a case-by-case basis. I'm not going to tell you that I have a particular case, although having done this in civil cases and in other cases, classically, there's a written waiver that is signed that you can waive that. And that's not done in this case. And my client is not a
Okay.
child. She was 19 at the time. They had the waiver from her. They never got it. And here's the problem for all of us in this case.
Okay.
There's a huge problem. Is mass media, social media, how it got out is, I guess, an issue that the district attorney and I will have to look to sooner or later. But the truth is, it got out. All these records, all these videos were out. Now, somebody from Artesia had to disclose that. Every one of them gave a statement to police. They shouldn't have without a waiver. They all gave records they shouldn't have without a waiver. They gave a video they shouldn't have without a waiver. Or and classically, when you read the case law, there are three ways. Number one, you get a waiver from the patient. Number two, a court orders it. There is no court orders in this case. They didn't go down and say, Judge, we need a search warrant. We need an order from you ordering the hospital to turn over the stuff to us. They never did that. They just did it. And then, in fact, there's a videotape in this case where the officer goes in and asks the administrator of the hospital, what do I need?
So we've seen all these videos, right? We watched all this body cam, all the, hallway surveillance from the hospital. We saw all of that. Right, Brenda, right. It's a whole HIPPA, Miranda. So I'm thinking that they're going to be able to use the hallway surveillance video from the hospital. But as of now, they're not going to be able to use the body camera of inside the room because the police were there. So,
To do? He says, well, just send me.
and I'm going to speed this up. I'm going to bump this up to like 1.25 or 1.5 so we can get through this because there's another video that I want to get to with you guys here shortly.
An email. That doesn't cut it. It doesn't cut it under HIPAA. It doesn't cut it under this rule. So my point is that the privilege applies. Now, I could choose to waive part of that as her attorney, or she could waive part of it. We haven't chosen to waive any of this. And as a matter of fact, the state knows this. At the very beginning of the preliminary hearing in this case and the motion, what I did was
This is where the troll comes in and starts muting them like every few seconds, and it's very irritating.
Mr. Mitchell, I was muted. You're muted. Something happened. I don't know what. Can you can you repeat everything you just said? I am sorry. My
Fine.
screen muted
I
you.
don't know how long I was muted for, but
Let's go back about 60 seconds, I think.
well,
I'm sorry.
here's the point, Judge. I've never waived this on behalf of my client. My client's never waived it. At the preliminary hearing in this matter and the motion to set conditions of release, I objected right before we ever got started receiving
Both,
evidence
Luna, I think
to
both.
the court, exercising the privilege, alerting the court to the issue, alerting the court to HIPAA, alerting the court to the doctor-patient privilege, and my belief that it covered Artesia General
Yes,
Hospital in this
Margaret.
case. And he gave me a continued
A troll peeps their way into their Zoom conference here. And because they have it open. It's an open Zoom court hearing. And someone didn't put safeguards in place to take away, people's ability to control audio and video. And yeah.
continuing objection throughout the entire hearing, and I've never waived it since then, and I've never waived it before this court. So that's what we think is covered by the privilege. So all these medical records, all of these statements by doctors and nurses that were taken without waiver, all of the lab reports, not the state lab reports, not those that come on the examination of the baby, but those that were examination of my client, that would be the blood test results, pregnancy test results, things of that particular nature. All of that is privileged. Everything there is privileged and should never have been disclosed. And we need a determination from the court that it's privileged. And if the court decides it's privileged, then unless I waive it, or there's another, and I don't know of any other reason, because the privilege is a privilege under Roper and Bertrand and the rule, that remains privileged and cannot be used in court. So that's the argument on the privilege, and I'll submit it to the court in that regard. And then we can argue the suppression issue later.
Okay. All right. Thank you. And I'm looking at the act. Privilege is that to be claimed by the patient or their guardian or custodian, which doesn't apply. It's a personal right by the patient. And it says who may assert the privilege on their behalf would be their physician or whoever treats them. Authority to claim the privilege is presumed, absent evidence to the contrary. Exceptions, well, it says by order of the court. Okay, so I understand what I'm looking at. Let me hear your side of this argument, Ms. Luce.
Your Honor, basically defense in their motion raised three issues. They raised the issue of Miranda, they raised the issue of HIPAA, and they raised the issue of privilege by the rule. Let me start with the issue of Miranda. Okay. The issue of Miranda, she was not in custody. Statements that she made when some police were there were actually statements initially that she blurted out. Officers asked her no questions. And then her mother, who is present with her in the treating room the entire time, is saying things to her, and the officers actually tell the mother to stop, that she, has Miranda rights and that she should be advised. And so we think the Miranda issue is really not an issue. There's not a violation of Miranda. And we put that in our response. The second thing is HIPAA. The defense puts HIPAA in here. HIPAA is really a red herring. It has nothing to do with the criminal case. There's no remedy. It's not a constitutional protection. It's a statutory protection in which a penalty can be against the facility, the physician, and that is the civil suit that two civil suits, I believe, that defense counsel has already.
Yeah, I think Mr. Mitchell doesn't disagree with you on that point.
Right. Well, no, but he put it in his motion, Your Honor, and so okay, for purposes of the record, the state's just making an argument.
But he acknowledged to me that the HIPAA is it's a federal issue. It's a remedy that doesn't even run to the patient, apparently.
Right.
Right.
Okay. So it really had no place in his motion, but it was there. So the third is the rule. And so let's start with defense has kind of combined a lot of things together. Statements made by treating personnel, doctors, nurses, records, video. He's kind of lumped all that together. The state doesn't believe that's proper. First of all, the defendant's mother, this defendant is an adult. The defendant's mother was present at all times. You can't have privilege if a third party is present in a room. And so.
You just went mute again. I'm having trouble with this. I think it's our system. Okay, go ahead. It's about 10 seconds. Okay, go ahead. I think.
the defendant's mother is present in the room with her at the emergency room. She's not with her in the restroom, but she's with her when the nurses, doctors, anyone is speaking with her. You can't have a privilege if you have a third party present. You've already, by your own actions, letting your own mother be there, waived that privilege. So statements that are made are not going to be protected under this rule. She's an adult. If she was a minor, that would be different. So statements, that's one thing.
You're muted again.
Records, the hospital records, the police department was given the records, but they did apply for a search warrant and obtain records.
Stay safe, Morgana. I'm going to be watching, keeping an eye on my weather too. So just an FYI, but you stay safe. Yeah, stay safe and keep us updated as you can.
Properly by court order. And so a claim of privilege that we didn't get them by court order for a crime, the state believes that that is the exception and allows us to use those tests from the lab as well as the records. The third thing is apparently the claim of the security video for the hospital for the hallway. The state would submit.
You're muted again. Okay, go ahead.
Yeah, Your Honor, it's showing that there's somebody on as a participant that is muting people, just so that the court knows.
Okay, that's good to know. If anybody's trying to mute, please stop messing with the system, all right? You can mute yourselves, but please don't mute my litigants here. All right, go ahead.
So, Your Honor, the video in the hallway, defense is arguing that that video is privileged. The hallway would be a public corridor within the hospital. It's not a private patient room. It wasn't the restroom. The fact that other people can access that hallway and be in that hallway, we don't believe that there's any right of patient physician confidentiality for a public hallway. It wouldn't be any different than when the court has a closed proceeding in the courtroom. Whatever's going on in the hallway of the courthouse is not a protected, secluded area. And so for them to try to argue that because it shows a bathroom in the hallway where she comes in and out of, that doesn't make it patient protected privilege. So I think really you have to separate out the three.
Again, go ahead.
The three types of evidence involved, from statements that are made where her mother is in the room and then later the police are in the room. It's definitely argument for defense counsel to say that the doctors deliberately, intentionally waited for the police to go in. I think that's probably at this point an assumption on behalf of defense counsel because we've had no doctor testimony to say that. But either way, the fact that the mother was already in the room, there's no right of privilege. There's no claim of privilege that's been waived. She came with her mother. She allowed her mother to be present. The court would be familiar that a patient has a right to not have other people in the room. They ask if it's okay if that person stays. That's normal treatment. The state would submit. So, Your Honor, we believe there are three different things going on here. And for defense to lump it all in and say it's all privilege before the court, we would disagree. And so we don't believe there is a privilege based on our argument to the court. I do have the officers on if the court wants to hear from them, since it is a motion to suppress of what happened once they were there. Once they were in the room, they were then had body camera. The reports have been submitted. I don't know if the court deems that sufficient. If you want to hear from them, that the state is glad to put on these witnesses. We would also ask Your Honor to be able to submit proposed findings and conclusions because this is a rather intricate argument, and I believe the way the defense has framed it and the way the state is framing it are very different. Thank you.
All right. And it is apparent to me there may be some distinct acts or events that occurred that are privileged or may be privileged. I'm seeing other. I can't lump this into one event, a long-running event. I think we've got, for example, I'm thinking that the whatever happened in the hallway, which I think is just a video of her going from, I guess, a treatment area down the hallway into the bathroom, right? That's a public area. I can't see that video would in itself be a privileged video. I've got other questions about other parts. I do think it's a good idea that you submit findings of fact in this case. I'm going to go back to you, Mr. Mitchell. I've got to tell you, I don't know how much of it I did see, but I was aware, I think it was around the time the pretrial detention hearing was occurring, which I did not conduct. That was not assigned to me. That was Judge Finger. There was something on the news, one of the Albuquerque channels, which I think was the video you're referencing. I think there was a physician, I guess he was an ER physician.
Judge, you're on mute.
Yeah, I just was. Who is
You
it? Something, Jad. Okay, somebody named Jad SD56 is muting us. Please stop. I'm going to have to ask him to leave this hearing.
He just left the meeting, Your Honor.
Okay, well, that helps.
And Judge, you were asking a question when you went on mute.
Yeah, I think I was telling you that I saw part of, I was just passing through a room in my house and there was some news report. This was immediately after the pretrial detention hearing was conducted. And it shows a video. It shows I think it's the ER doctor. I don't know. I believe it was. And there was a police officer. I thought it was a state policeman, a police officer. And there was conversation going on. That's about all I know about that. That's the one you're referencing. Is that right, Mr. Mitchell? That she was
No,
not- no.
No, that
Okay.
that came from an interview later on when the police are interviewing the various nursing staff. That's a charge nurse that you're talking about,
Oh.
that you were talking to. He also was the one that took the baby from the bathroom into an examining room and called the doctor to come down. That's a charge nurse.
That's different. So talk to me about, here's what I have on my mind about the state alleges that Ms. Trevizo waived any privilege by allowing her mother in the room when she was in this, you say it was custodial investigation or interrogation. She was, is anybody, she was advised she was not free to go, right? Is that undisputed?
Well, they say so in their reports. And Judge, I gave you the video. You have the video among the exhibits I produced.
Oh, okay. Okay, I'll see that later then. So,
You can see exactly what happened. But really, in answer to the court's question, number one, my client's mother came with her into the emergency room.
Mhm.
And she was present, except when she went down into the bathroom. She was not present in the bathroom.
Mhm.
She was present during most of this. And then she was present later on when the doctor and the two police officers come into the room. Now, I want to be real clear about these facts. After the 18 minutes, you see my client go down the hallway to the bathroom. And then 18 minutes later, she leaves the bathroom and she comes down and goes back into the examining room. Now, the doctor went into the examining room to do a quick vaginal exam because they didn't know what had happened. They had not found the baby at that time.
Okay.
And they do a quick vaginal, she gets undressed, they do a vaginal exam. None of that's recorded, obviously, on video. It's in the privacy of the room. The doctor's there, but they have not found the baby yet. And so, again, the mother is present then. I want to be upfront about this. And then the cleaning staff finds the baby, and then they call the charge nurse. The charge nurse takes the baby into an examining room and then calls the doctor. And then it's after that. And this was testified to, and I know, I say this very respectfully to Diana. She wasn't the attorney that handled the preliminary hearing.
you're muted again.
I don't know what's going on there, but I'll keep my finger on it, Judge.
I know, I'm not touching a thing. And
We may have so many people on there that's the problem. Anyway, I was saying that after they find the baby, then is when the doctor, who also testified at the preliminary hearing, indicated she waited after they found the baby to go back and talk to her patient, my client, until police got there. They called 911. The police were there. We're not talking about a lengthy period of time here. We're talking about within minutes, really quick. And the police were there. The sergeant comes, the officer comes, and then then they talk to the doctor. They go in the room, and in the room at the time is my client, her mother,
Yeah, at this point, Steph, they said that her cervix was, so, yeah. Brenda says, I have to go. I'll catch the rest on replay. Have a great rest of your day, Brenda. Hey, Michelle, good to see you. But Brenda, have an amazing rest of your day, ma'am. Have a great rest of your day. We're about an hour and a half in, Michelle. We've been just watching this hearing. I don't know if you've already knew this, that unless something happens, I guess back in June or May, there was a motion to suppress, and apparently the body cam footage and stuff from the police officers inside that room, her hospital room, is going to be thrown out, not played in front of the jury. HIPAA laws and stuff. Remember we were talking about that the other day? Apparently the judge granted the motion to suppress, and none of that police body cam footage is going to be played.
Doctor and the two police officers are standing and she can't leave. And that's in their reports that by that time they've got this
Okay.
information. They have a baby that's deceased. They have a doctor, they have the baby, and they have information, and they're going in to talk to the mother.
And let me interrupt you there now. Ms. Luce has asserted that because her mother apparently was already in the room, that statements made by your client were, I guess, impliedly waived because her mother was, and she's an adult. I think it's based on that. I mean, if she were a minor.
Right, but I'm not sure how much of their testimony will be able to be used. Dusty Gary. I know.
Be a different situation altogether. Can you address that?
I can, and you need to address it in two ways. Number one, what does the presence of the mother do to the medical doctor-patient privilege? That's number one. Number two, what does it do under Miranda suppression rules? Well, the latter first. Under Miranda, it doesn't matter who's present. They have to read her when she's in custody and she couldn't leave. The officers were there. They say it in their reports. And then they don't read her Miranda. The doctor asks a question. And you can't do that. I've cited some cases and wrote on that in the response or the reply to the response. And that's a different situation. And Miranda would still.
You're muted again.
And whether or not that gets suppressed or not is the determination the court has to make. That's a different and separate issue. Now, does the privilege at the hospital apply with the doctors and everything, with the mother being present? My position is, I'll try to do some further research on this. I agree with Diana. We need to do findings and conclusions and give you some case law about this, so you're not deciding this thing in a vacuum. But my position is the doctor-patient privilege still applies because we do this all the time in hospitals. We have spouses present. We have family members present because they brought them in. And a lot of times the people aren't in their right mind to make decisions anyway and need a family advisor. We do this in hospitals all the time. I'm sorry, it doesn't get. Wow.
Well, okay, you're good.
Wow. It doesn't get rid of the privilege.
Right, Michelle? She says last year we all thought Lexi was a cardboard cutout sitting there. She doesn't budge, but maybe once. I know. I saw her budge a while ago. She was like scratching her leg or something. But they were saying a while ago, some of us were talking about, I think it was Chaloon said that she thought that mom was probably under the table because, she's so controlling that she's got to be there. So they're like, just hide under the table.
It's my position.
All right.
Oh, and also, Michelle, there is a poll. And if anybody else has missed it, there is a poll in the chat. Please vote. It is very important. Thank you very much.
That's what and that's going to be a real important factor for me to examine and I do think before I make any really hard decisions, you're getting my impressions on stuff, but I would really like to have your finding of facts, conclusions of law before I really have studied this. So that's something I'd like both sides to.
So that's what she's done. She says she needs the whole finding of facts, all of that. She needs to really look at it. It took her dang near a year to decide on this motion, but I guess, like I said, it was back in May that she granted this motion to suppress. So,
Give me some authority on it.
and also they talk in here about the boyfriend and how there's like there was like a something set up where she couldn't see the boyfriend, and I think that the judge lifts that. We won't watch all that because I don't really care about that, but
About that. Is it impliedly waived if you allow another person in the room? All right.
All right, Judge, that's that. I think the other issue was this that you had before you today was a modification of the release provisions. Judge Finger cited to the domestic violence section.
yeah, that's basically all that's left. So we're going to cut that. We're going to end there, and then we're going to go to this is the motion that he filed to suppress. Comes now the defendant Alexee Trevizo through her attorney, and gives notice of privilege, moves to suppress all evidence received in violation of her doctor-patient privilege. About the HIPPA. And then it says she also moves to suppress all statements taken in violation of her constitutional rights pursuant to the Constitution of New Mexico and the U.S., specifically taken in violation of the mandates set forth in Miranda v. Arizona. So, this motion, it just goes through, it's like 14 pages long, but it goes through all of the information that he basically just talked about. Talks about here, like number 13 says, Alexee Trevizo is age 19, gave no consent to disclose her medical records, videotapes, lab tests, reports, videos, pictures, personal stuff. She did not consent to her doctors or any of the staff disclosing her confidential information or to the Artesia Police Department disclosing it to the public. Sadly, all have. All of these little blurbs, basically everything that he talked about there in that, he filed the motion to suppress all of that information, all of that videos and all that. All right. Now here is where we have, and that was filed, that motion that he filed was on July 24th of 2023. Okay. And she said she needed the finding of facts and all of that. So then we have, is this the one I'm sharing? Yeah. Okay. The findings of fact and conclusions of law of the court. This is the findings of fact. There were 7 pages of that. It basically just goes through all of the other information, the same things. Here, hold on, let me find. Where was it? Number 5 here says the timeline of pertinent events is as follows. Michelle, no worries. You can say I'm from the South. Yeah. ish. Triage date, they give the date January 27th, all of that. And then it goes through the timeline when the medicine was given, the positive pregnancy test, all that stuff. And they go through when the police get there. Conclusions of law here is where we get into her decisions. Trevizo had not waived her privilege to confidentiality when she was confronted by the statement from Dr. Vasquez that we discovered a baby in the bathroom. Dog walk time. Ooh, go find a handsome man. Handsome man. That's where Chaloon's, they need an app for that, right? Because Chaloon goes and walks her dog because she finds hot men that way. Okay. 2, Trevizo did not waive her privilege, even though her mother was present, because she had designated her mother and stepfather as persons who were her caregivers and as persons to contact in an emergency. Vasquez, by failing to advise Trevizo of her right of confidentiality, and this is written by the judge, okay? These are her conclusions. Vasquez, by failing to advise Trevizo of her right of confidentiality pursuant to rule blah, 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 by failing to invoke the privilege on behalf of her patient pursuant to rule, and by entering only when accompanied by law enforcement, acted as an agent of law enforcement. The statements made by Trevizo in response to the accusations made by her physician, who was by then acting as an agent of law enforcement, were made without Trevizo being advised of her Miranda rights. By the time Trevizo made her statements in response to the remarks made by her physician that a baby had been found, Trevizo was surrounded by law enforcement officers, and she was not free to leave, and she was therefore effectively in custody. It's supposed to be Michelle, yeah. I mean, her scheduled date for the trial is August 26th. I think it's August 26th. Roundabout there. She does have another hearing on the 22nd of this month. So, statements made by a defendant who has not been advised of their Miranda rights in the presence of law enforcement in a custodial setting are suppressible. The statements made by Trevizo in the presence of law enforcement and elicited by her own physician are thereby suppressed. The respective parties' finding of fact and conclusions of law not contained herein or not consistent herewith are hereby refused and denied. This is very unsettling. Very unsettling. Vasquez did not have any communication with her patient, Trevizo, regarding the hospital's discovery of the deceased newborn, except in the presence of 2 law enforcement officers, and the news, as delivered by Vasquez, was done in a highly confrontational manner. By refusing, or at the least failing to give shocking information to her patient except in the presence of law enforcement, made Dr. Vasquez an agent of law enforcement. Thereby, Vasquez and or law enforcement was at least obligated to give Trevizo her Miranda warnings. As her treating physician, Vasquez was obligated to honor and invoke on the patient's behalf the physician-patient privilege. Vasquez did neither. In further consideration, the court notes the morphine had been administered IV to Trevizo within a recent period of time when she was confronted by her physician. It is not known to the court how much morphine was administered to Trevizo, but certainly enough to have crossed the placental barrier such that the deceased infant was found to have had morphine in its heart blood. It is undetermined whether Trevizo may have still been under the influence of a narcotic drug when she made her statement. Uh, Vasquez crossed over the line from a requirement to cooperate within the bounds of the law, which is mediated by the concurrent obligation to the patient, thereby making Vasquez an agent of law enforcement. She did so by waiting to be accompanied by 2 law enforcement officers before delivering the implied accusation to Trevizo that Trevizo had committed a crime. Counsel for defendant shall prepare an order suppressing the statements made by defendant Trevizo consistent with the court's findings and conclusions. Signed, Judge Schuler Gray, District Judge. All right. So let me go up here into the chat and see what I missed. I don't know, Margaret. Social work and nursing. Oh my God. Oh, Brenda's back. Welcome back. Welcome back. Welcome back. Welcome back. Nursing, are you frog logging? Yeah, you kill me. No. Thank you, Michelle. I appreciate that. Steph's always like in protective mode, right? You know how hard I tried to be a nurse, and because it was so competitive where I live, I couldn't get into a school with a 3.8 GPA. That's really frustrating. Oof. I mean, I think that's a great GPA. It got me only 1 out of 20 points for my GPA for getting into nursing school. Wow. I thought it was a mistake that she wasn't read her Miranda rights. CLR Bruce Rivers, awesome YouTube creator, mentioned this. He's a criminal defense attorney. I don't know that I know him, and maybe if I see his face or hear his voice. But what do you mean a mistake? Mm, this is BS, but somehow they got her high-powered attorney. Her high-powdered attorney. Michelle's killing me. You guys crack me up. You look too young to know the Welcome Back Cotter theme song. Oh, honey, I grew up on Nick at Night. Okay. I didn't watch it originally. I watched the reruns on Nick at Night back in the 90s. I love me some Cotter, though. Because since she didn't have her Miranda rights read to her, anything that happened in those rooms would not be admissible. Right. Okay. I thought that's what you meant, but then I was thinking maybe, I didn't know if you meant that you thought that they had read her rights, but that it wasn't caught or I don't know. You watched it originally? Margaret did too. She was little though. All right. So you guys, this is a train wreck. I don't even know what to think about this. I don't know what to think. I'm sad about it. Now the state has filed an appeal. They filed their appeal of this suppression granted motion. It looks like about 4 or 5 days ago, the 3rd of this month. So, here's the newest. Here filed 7/3/2024 at 5:03 p.m. They give the relevant factual background. January 27th, defendant was admitted to Artesia General Hospital around midnight. I'm just looking through here to see. Man, I'm hoping that we get an answer to this on the 22nd of this month, because they're supposed to have, like I said, another hearing. Steph watched it on Nick at Night in the 90s too. At my dad's, where I was allowed to stay up late. All right, so this appeal, they're just basically appealing, right? The decision. So, they have to be able to say how she arrived, what she did, what they found, how they found it, and then the autopsy proving the baby was alive. Right, they do have to be able to prove that. I just don't know. Ms. King says, again, another case that was performed in the correct way. If she was not free to go, they should have had given her her rights. Exactly. And it's so frustrating. Statement of the court's jurisdictions. This is a pretrial appeal by the state from the June 3rd, 2024 order granting Alexee Trevizo's motion to suppress entered by the Honorable Jane Schuler Gray. Defendant is charged with first-degree murder, or in the alternative, intentional abuse of a child resulting in death. Defendant is also charged with tampering with evidence. Because first-degree murder is a capital felony that carries a sentence of life imprisonment, this court has exclusive jurisdiction over this pretrial appeal. This appeal is pursuant to this big, long, blah, blah, blah here. A timely notice of appeal was filed in the trial court on June 6th, 2024. It says the statement of the issues is timely filed on or by July 8th, 2024. I don't want to read through the relevant factual background because it's just reiterating everything we've already talked about and watched. And then they go over the motion to suppress filing. The state's response here, it says the state filed State of New Mexico's response to exercise of privilege. The state argued that HIPAA did not preclude medical providers from disclosing information to law enforcement regarding a crime committed at the Artesia Hospital. The state also pointed out that some of the information defendants sought to suppress was outside the scope of HIPAA or could be permissibly disclosed to law enforcement. The state also argued that defendant had waived any privilege under Rule 11504 because she spoke to her physicians in the presence of police officers and her mother. Regarding Miranda, the state argued that the defendant was not in custody and that when the physician entered the room and advised that a dead baby was found in the bathroom, defendant immediately replied, "I'm sorry, it came out of me. I didn't know what to do." The state also pointed out that after law enforcement advised the defendant that she was detained, they advised the defendant's mother to stop questioning defendant. Finally, the state submitted that the demand for an in-camera review under Pena v. Espinoza was premature. Um, hmm. And we have the defendant's reply. Although defendant conceded that HIPAA does not have a suppression remedy, she went on to reiterate that she did not waive any privilege and that she was not informed by any such privilege. She continued that she should have been advised of her Miranda warnings because the doctor and police worked together to elicit statements from her. They mention here in this footnote, in preparation of the statement of issues, the state requested the August 22nd hearing. The recording is difficult to hear, and for unknown reasons, it appears that a courtroom attendee muted attorneys and or the district court at various times. That was the troll. They go over here what just happened in the August 22nd hearing that we watched. Post-hearing pleadings. Probably Rosa, right? Post-hearing pleadings, both the state and the defense submitted findings of fact and conclusions of law, and defendants sealed findings of fact filed on August 30th. Defendant requested conclusory factual findings, including that the ER doctor refused to speak with defendant until the police arrived, that the defendant was not free to leave and was detained. Defendant conceded that her mother was in the room with defendant during her time in the hospital, but that her mother's presence in the room did not waive any physician-patient privilege. Regarding Miranda, defendant summarily concluded that when the doctor informed defendant regarding the baby found, such was a custodial interrogation requiring suppression of all of the defendant's statements. In the state's sealed findings of fact and conclusions of law filed on September 12th of 2023, the state, citing to the body camera footage, submitted that Dr. Vasquez entered the treatment room and calmly informed the defendant that we discovered a dead baby in the bathroom. Upon hearing the physician's statement, the defendant immediately replied without prompting, "I'm sorry, it came out of me. I didn't know what to do." The state submitted that defendant was not under arrest or restraint when she made that admission. The state submitted that the exchange between defendant and the physician did not rise to the level of a police interrogation. At that time, she basically just said, "We have to get the police involved." The state also submitted that Rule 11504 and HIPAA allowed for hospital staff to communicate with law enforcement regarding the commission of a crime, and that defendant was aware of the hospital's obligation when she signed a patient acknowledgement of rights form. Further citing to another case study here, or case citing here, it says the state argued that the defendant waived any privilege when she made statements in the presence of her mother and law enforcement officers. On May 13th, 2024, the district court issued its findings of fact and conclusions of law, which did not cite any case law. Ooh. Essentially, the district court determined that Dr. Vasquez was acting as a police agent the moment she walked into the defendant's room. Yet, at the hearing, the district court was not presented with testimony to suggest that Dr. Vasquez planned her entry into defendant's room, that her only purpose was to elicit incriminating statements from the defendant, or that she acted in concert with law enforcement agents. In fact, the medical records that defendant provided to the state, as noted in footnote 2, indicate that Dr. Vasquez performed a pelvic exam on defendant prior to learning that a dead infant had been found in the bathroom trash can and prior to police being called. Then the district court found that when defendant stated, "I'm sorry it came out of me, I didn't know what to do," defendant was detained, and that Dr. Vasquez and or law enforcement officers were required to give defendant Miranda warnings. The court also concluded that Dr. Vasquez failed to honor and invoke the physician-patient privilege on the defendant's behalf, but instead acted as an agent of law enforcement. The court also raised whether the defendant was under the influence of a narcotic drug when she made the statement, an argument not raised at the hearing on the defendant's motion. The district court's order granting defendant Alexee Trevizo's motion to suppress followed on June 3rd, 2024, which just happened. The order granted suppression of all statements made by the defendant to her medical providers on the basis that the doctor-patient privilege applied, and granted suppression of all statements made by the defendant in response to her physician in the presence of police officers. The court did not exclude the medical records or the hospital video showing defendant entering and leaving the bathroom. So that's what I was talking about. The judge didn't take away the hallway footage that we watched from the hospital camera. Related or prior appeals. There are none. Conclusion. The state respectfully requests this court to place this case on its general calendar and reverse the district court. So that's that. Now we wait. Now we wait. Now we wait. Might as well read someone their rights regardless. True. Nothing bad can happen from reading them, but a lot of bad can happen from not, right? Like this. You'd think what we've learned about her mom's experience with law enforcement, that old mom there would have known to tell her not to talk. Or I'm just being facetious, or both. Absolutely right, Mom. Yes. Why the heck did they not? I mean, if it was that important to get the police involved, why wouldn't they not have done it properly? It's very frustrating, Michelle, right? I don't feel that you have any right to protection of your medical history when you commit a crime. That would absolutely trump that protection. No, right? I know, no cap. No lie, no cap. That's true. I don't understand that. Like, I don't understand the little intricacies of, that's what I said. It's like a big, giant, massive ball of yarn that's all tangled and twisted up. And you're trying to untangle it, but it's untangleable in my head. Like, I can't untangle it because none of it, it all intertwines. Like, when does it go from patient doctor to defendant or subject police officer. You know what I'm saying? And then you have the baby in the trash can. You know, I'm just like, how do you? I don't understand. Yeah, she was not a minor. She was 19. 19. Apparently, yeah, the court didn't give any case law on that. Whatever. That was lazy. That was lazy pants, right? Hospital was trying to do everything right, considering a crime had been committed by the person who discarded that poor baby in the trash. I pray she does prison time, but with this, and I don't know what testimony that they're going to allow to come in from the witness, from the staff and the police officers. I don't know what they're going to allow to come in. That's why they called the cops, but then there's all this intersectionality of law and medicine and all those protections. It shouldn't be this complicated, right? That's what I want. That's what I'm trying to say. Like, I want to take that comment, Patricia, and make it the whole of everything I've tried to say about this motion to suppress crap. Her mom didn't tell her to stop talking. The actual cop did. He's like, Mom, mhm. He's like, the detective is coming. She can talk to him. Oh God, Steph. I did not need to know that. Now you guys know. Again, Michelle, meet TMI Steph. That's why we call her TMI Steph. It could be argued that after the charge nurse took the baby out of the trash, the baby became their patient. Well, yeah. I mean, yeah. But "19 is old enough to know right from wrong." She had to know she was pregnant, feeling the baby move. Wait, she knew she was pregnant. And hi, Billy. She absolutely knew she was pregnant. There's no doubt in my mind. Absolutely no doubt in my mind. Hi and welcome, Billy. How are you? I hope you're doing well. I know, Margaret. I knew you were going to say that. I know. I know. That's why we love our girl. That's why we love our girl. That's why we love our girl. Hold on just a second, you guys. I have to check. I have to check up on the weather real quick. We're getting warnings and alerts left and right. Hold on. Goodness gracious. All right. So Steph said there, I made it fancy. Oh my God. No, Steph. Oh God. Y'all nasty. Patricia said the cops didn't know all the medical laws and the doctors don't know what's allowed or not legally once a crime has been committed. There can't be this much gray area in a situation like this. It's taking HIPPA too far. The Miranda rights, I get. I get that. The cops know when they come in, if there's something going on, read the rights. Right? the doctors she's like, the doctor is like, a crime was, even if a crime wasn't committed, there's still a dead infant in a trash can. I mean, that that's reason to call the cops. So, um hold on just a second, guys. I gotta check on the dog real quick. Hold on. All right. Let me catch back up in the comments again. Heat advisory, and I'm cleaning, and my AC ain't cutting it against the outside. Oh, yeah, I know. Mine's having a hard time keeping up, too. Mine is having a hard time keeping up, too. Brenda says, so will that 19-year-old turn around and sue the hospital for malpractice of her? But she did. She actually did. Yeah, they have a suit. Wrongful death suit against the hospital, Brenda. Absolutely. Billy said, good. It's 97 in Washington State. So hot, hot, hot. No AC, just fans. Oh my God. Right, Michelle? It is miserable. The humidities are awful. Thanks, Steph, for keeping your sister straight. I know. I know what you mean, Patricia. I get it. I know. Accountability Act, Patricia. Oh, is it 2 A's? I thought it was just 1 A and 2 P's. Well, I screwed that up in the... Wait, is it HIPPA or HIPPAA? Because I'll have to redo my title if I've screwed it up. You dropped to 79. Oh, it's HIPAA? Lord have mercy. Only 1 P. Okay. And 2 A's. Well, I need to fix my title then. Hold on. Let me write that down. Lord, Lord, Lord. I guess I'm just used to spelling hippo. I don't know. When you used to work for that industry 1,000 years ago. Ooh. Okay. One more brief second. Hold on a second. Hold on. Okay, you guys, sorry about that. It's a crazy pants time of the day. It always gets kind of crazy about this time of the day. Um, Kiddos and such, right? Um, Good night, Lauren. Have a good night's sleep, ma'am. It was good to see you today. Margaret says, y'all, my unemployment checks start this week. I'm so excited I could just frog log. Oh, yay. I'm glad. I'm glad that you're getting all that stuff squared away. But I hate that that you were done the way you were done. That's no good. That's no good. Let me go over here and check the poll. We had, oh, wow, you guys. Okay. If you haven't yet voted in the poll, I'm going to give you just a few more seconds. I'm going to count backwards from 5. And if you haven't yet voted, please go vote. We have 19 votes currently. Okay. So I'm going to count backwards from 5. 5, 4, 3, 2, 1. All right. Ending the poll now. I think they finally got Jenny's letter that you needed to be at the crime cafe instead. All right. So here we go. The poll was the question was, which upcoming topics do you want to discuss or watch? And the vast majority of you voted for the Alec Baldwin trial. I'm a little bit shocked. I'm a little bit shocked, not gonna lie. So, looks like we're going to be covering the Alec Baldwin trial. And then next in line was Jocelyn Nungaray. 26% of you voted for that. 15 voted for Sherry Papini, and 10% voted for Rachel Sheridan. So, Steph said, I'm surprised you put it in as an option since you don't care about that one. Well, I mean, the thing is there's one of me and multiples of you. So you are why I'm here. And everybody loves a good trial, right? I know. And I'll just have to figure out a way to you know, gonna have to come up with a way to still discuss these. I don't discuss these other stories like we've been doing because I've enjoyed that a lot. And we'll figure it out. Alec Baldwin, Margaret. Yeah, I know. My husband's going to be really interested in that one. So, and I'm just kind of neutral on it, you know. I mean, I love trials. This one just wasn't my we could speed watch Baldwin. I could start them late. I also need to figure out oh, wait, Michelle, heads up before you go. Thanks for coming and hanging out. Also, I'm going to end this, but I'm starting another stream here momentarily because you guys, I'm just going to tell you right now, we're going to talk about it. There was breaking news today. Gypsy Rose is pregnant. She's pregnant. And we're going to talk about it. I know that you're like, but true crime, Gypsy Rose being pregnant isn't true. Well, but we follow up with true crime things, right? that was a true crime story with Gypsy Rose. And we're going to keep up because she's pregnant, you guys. She's pregnant. Ugh! And we're going to talk about it. So give me a few minutes, okay? I saw this come up on my phone and I was like, oh my God, let me go straight and make a thumbnail because we're going to talk about Gypsy Rose. No, well, we're going to talk about it, Steph. We're going to talk about it. So I know, Michelle, I can't, you guys, she's having a baby. All right. Have a good day, Michelle. Cray, cray, cray. I know. Yeah, she's pregnant. So we're gonna go peep in on that news here momentarily. I'm starting a separate scream. I feel like screaming, right? Right, she's pregnant. Stream. So yeah, we do gotta talk that out. We gotta talk it out. We gotta talk it out. We're gonna have a discussion about this. I can't. All right. So I'm gonna end this and I've got it ready. I just need to schedule it. I need to see when the husband's coming home. I have to go do some kid things. So let's just keep your eye out. Make sure you have your notifications on, okay? And we will talk about that momentarily. All right. Just give me a little bit to do all the kiddo things and stuffs. But I'm gonna get out of here for now, but we'll see you back momentarily. All right. Thumbs ups, please, and thank you. Hashtag replay if you're watching later. And like, subscribe, all those things. Share me with your friends. Okay. Share me with your friends who love true crime. And we will see you back in a little bit. Love you guys. Bye.